Good evening, sir.
Good evening, sir.
Good evening.
How are you?
It is
Absolutely.
still, it is still fine.
Yes, sir.
It is still
Evening,
7 minutes. You should wait 7 minutes.
9:53. Yes.
So,
Yeah. Ideally,
oh, thank
a
you.
lot more people
Yeah, of course.
until every
Okay.
will be here. Hello, everyone. Assalamu alaikum. Sir is also online, and I believe, sir, there's already people joining. There will be a lot more who are joining us. We already have 20, 25 members with us. So, don't move away. First of all, I would just like to inform everyone that this meeting is being recorded and transcribed. for future upload purposes. And secondly, all of you are requested that while sir is providing the lecture and speaking, kindly keep your mics and your videos off. If needed, sir can allow you to ask questions during the lecture. Otherwise, at the standard Q&A session at the end of the lecture, all of you will be allowed to raise your hands and ask questions accordingly. So with this, we are just 1 minute away, and apart from that, I don't think there's any other thing I need to inform you of. So Bismillah, and sir, let's begin.
Bismillahirrahmanirrahim.
Bismillahirrahmanirrahim.
There must be some lawyers to whom I impliedly know, but I have a little bit interaction with. I hope everybody must be very young and budding lawyers. I don't know the age of the lawyers.
So it is a pleasure to have you here. Absolute pleasure and our privilege.
So nice of you, all of you. Welcome to the first interaction. Good, because we all belong to one family. This fraternity is very important for us. And I'm very happy the moment I'm seeing young, energetic, enthusiastic lawyers who are joining this profession, a noble profession, which we have chosen. And we have chosen this profession by conviction and to have our honor to be respected. And that's why the lawyers fraternity is called to be as the cream of the society. Good. I remember when I joined the bar in 1985-86, hardly anybody would prefer to join. Everybody, after doing their LLB honors degrees, would try to prefer for some job. But since it was my ambition to be a lawyer, initially I also faced a lot of difficulties when I joined the bar. But at the end of the day, this profession will give everything. I think it's unparalleled, unmatchable profession. Nobody can match this profession. And I could see for last 37, 36 years of practice at bar, particularly the youngsters, they are very doing commendable jobs, working very hard. Yes, I am very happy. So today we have chosen a topic that in Civil Procedure Code, you see, Civil Procedure Code is very important subject, particularly in practice. And in our state, we have almost all 65% cases related to the Civil Procedure Code. So we should be fully acquainted with all the procedure and the provisions of law. For last 37 years practice, frankly speaking, the topic which otherwise, as far as Civil Procedure Code, I have been practicing throughout the country. There is hardly any high court in which I have not appeared. But this subject, Garnishee and Garnisher, why did I select it? I could not see here, particularly in this part, Kashmir, even in Jammu also, that people have concept about this Garnisher and Garnishee. It is related to the execution proceedings. You see, Civil Procedure Code, we know normally when a plaint is to be filed, we file the plaint where we have to contain all the pleadings. There's a different procedure in the writ proceedings, but the procedure in civil should be fully acquainted with all the facts, because civil procedure, under Civil Procedure Code, if a suit is to be filed, a plaint, there was no amendment earlier. Now you have to file the plaint in duplicate form. It is only after the amendment. And it should contain all the pleadings. More specifically, you have to highlight the pleadings because it is considered to be the bundle of facts, civil suit. You should not miss even a single. If you miss a single, then ultimately you may not be in a position to succeed wherever if you commit any type of mistake in the drafting. That's a very important thing. Normally, if we file a plaint under Article 7, we know it. And we contain all the pleadings, all the facts. Then ultimately we pray the reliefs in the suit. The execution proceedings are very important, because ultimately you will find when there's a decree, a money decree particularly, And then you will have to go for execution. Even other is also for other decrees also, restoring the possession, or even restoring the status quo ante sometimes also. So the execution proceedings are very important. If the decree has attained the finality, then you will have to go and to file a petition for execution under Order 21 Civil Procedure Code. There is also Section 47 of Civil Procedure Code, which would also deal with the execution. You see, you should be very frank with me. I think some 20 or 25 young lawyers, budding lawyers, because future would rest in you and it lies as far as our society is concerned. Please tell me frankly, how many among the CEO people have heard this? I don't know how much practice, must be having 5 years, 7 years, 10 years, or 12 years practice, or maybe more or less, have heard this garnisher and garnishee. Then I will explain.
Anyone who would like to answer sir's question can either do so in the chat, or you can now turn on your mic, so sir has requested, and just answer. For me, sir, for one, I will be very bluntly honest that before this lecture, I did not have the chance to look this up or research it, so I did it in the past few days. I read Order 21, Rule 46, and the related sections, and then how I found out, sir.
You see, I was doing in Bombay High Court. You see, a lot of commercial litigations are there. I could say because I have been representing national and international companies across the country. A lot of reputable companies to whom I am the senior panel. I could face this issue before the Bombay High Court. You see, if something is lost in sea, suppose you are dealing with in business of export and import of some goods, and you will have to send it to Europe, in any country. Like my client had to send some goods to Hungary, Budapest, is the capital of Hungary. So there was a decree. Mullah and Mullah is a very famous Bombay firm. I had done that case, and there was a decree against that Italian company in that. The Bombay High Court, normally these suits are called admiralty suits. We don't have that concept here. And in that admiralty suit, the decree was passed by the court, Bombay High Court, and that time the Bobde, Honorable Justice Bobde, now he was our Chief Justice also. I think he had his starting tenure as a judge in Bombay High Court. So his lordship, while passing the decree in that suit, maybe I think due to some technical error, did not mention about the registry to prepare a decree sheet. But that's also very important in civil procedure code. It's the 3 things: orders, judgments, and decrees, and then decree sheet. It's very important. Perhaps when there was no whisper or murmur about preparing the decree sheet after the decree was passed, and holding thereby my client to be entitled of the greater amount. And then there was a delay in going for execution also in that way. Ultimately, then when I was engaged in that case as a counsel, so basically there was some insurance policy in that also, in that case. United Insurance was not arrayed as a party in the main suit. The decree was against the Italian company. That Italian company had declared. Initially they appeared, filed a written statement, and thereafter they disappeared. Did not choose to participate further. And against them there was a decree, money decree, and the insurance company had insured those goods. Those were the garments that our client used to send it through sea from Bombay port. It was lost. It did not reach to the final destination of Budapest. And ultimately, we filed an execution. I took a very strong plea in that since there was no direction to prepare the decree sheet, and that was a mistake inadvertently committed by the court, and that the registry also did not prepare the deal. Unless there was a decree sheet, I was not in a position to go for execution. So that was heard by Justice Kolabawala, a very good judge on civil in Bombay High Court. And he agreed that there was no requirement, because you see, Section 5 of Limitation Act, if the decree is beyond 12 years of period for execution, that's the requirement of law. But his lordship was convinced after I argued it, considering there was a mistake committed inadvertently by the honorable judge, did not mention about preparing the decree sheet. We were not in a position to go for execution for all these. And our time would run only from the date. And the decree sheet was officially prepared by the registry of the Bombay High Court. So, without filing Section 5, because that was not a requirement even, Section 5 would not apply in those cases. So, his lordship permitted me, and by implication of law, he said that this can be treated. And then the question came, because that Italian company had declared that it had become the bankrupt. So that time, these insolvency proceedings or this DRT were not in operation. As you know, banking insolvency proceedings came only in 2016. Before 2016, there was no code like that. So ultimately, Justice Kolaba then, or rather his advice also was, which was welcomed, that Garnishee application is required to be filed, so that we can recover this decree. You see, the decree is always construed to be the weapon of the court. It is a type of equipment with the court. The court has to satisfy it. It is their property. It is the property of the court. So since there was huge amount in that case, that's still going on in Bombay High Court. I am expected to appear in that case on 6th of December. Again, and that process, the Garnishee application is in the process of arguing. We made one attempt, where I tried my level best to convince the court that we can recover it from the Garnishee. You see, this concept was not earlier there. It's Order 21, Rule 46 was already regarding for execution. This amendment was carried in Civil Procedure Code under Order 21, Rule 46A was incorporated in 1976. And this is a remarkable landmark amendment. That is why I did choose this subject. It's a remarkable and landmark amendment, which was made in the Civil Procedure Code, 1976. If there is a decree, and the decree holder would go for execution, and against the company, mostly we have to see whether, if a judgment debtor is not satisfying the decree, we would say that I don't have money, and I'm not in a position to satisfy. Then efforts are to be made to see if he has some money or some bank or some account in any bank, whether national or otherwise. Then we can go to the court and file an application to have the Garnishee order, so that the direction would go to the, in execution, go to the bank, that if this judgment debtor is having an account, the money is there, for the satisfaction of the decretal amount, the court would issue a notice first to the bank or any financial institution for the purpose of satisfying at least decretal amount. So anyway, even if that bank is not a party, but if the account, that company, again assume there is a decree and that company is a judgment debtor, has the account, has the money, the court has every power to issue a Garnishee order. You see, decree holder is called as a garnisher, and the Garnishee is that if the judgment debtor has having account or money in any financial institution, regardless of the fact whether that financial institution or bank is a party or not, is not concern of the court. This is a discretionary power, of course, not a mandatory, but is a discretionary power. But for the purpose of satisfying the decretal amount, the executing court can always direct the bank or financial institution to satisfy the decretal amount, so that the decree holder would get his decretal amount from the court. Directly, he can't give it to the decree holder or judgment creditor. He has to, on the basis of the Garnishee order, which the executing court can issue, in these circumstances, will deposit in the court, and thereafter the court will satisfy the decree. This is number one part. It pertains to the movable property, and even it pertains to the immovable property also. You have to only satisfy that there is also the third party, some immovable property where he owes money to the judgment debtor, and the court can recover, so that it is given to the decree holder. This is a very important concept. Immediately after the amendment, which was carried, I've hardly seen, but this in day in and day out, you would find it, particularly in the High Court of Mumbai, Madras, and even in Jaipur, I have also seen Rajasthan High Court, these type of litigation, even particularly Gujarat High Court. These type of commercial transaction litigations are there, where these type of proceedings I did come across. So this is the concept of the. Basically, I will not go into that. We have derived from the French word garnir. I don't want to go into that aspect, how it came in. But the only thing is a remarkable amendment which was carried in 1976. This is number one. Number two, today, since we are interacting with my pleasure also, that I am interacting with the young people. Before you will ask me any question regarding this or any type of question in the civil procedure code, don't worry. I will try my best to satisfy all of you. But I would also, I feel it pleasure, my pleasure, to ask, and if anybody among you will give me a reply to that, I promise that I will reward him. He will have to only give the details on my email, or will interact with Danish in a very nice way. I will award him in terms of money, because he should be also encouraged. I will give him fees. Oh, please tell me. After you can ask me any question, no problem. I relate to this subject or any other subject under Civil Procedure Code or company matters or any type of bankruptcy code or criminal matters. I am also dealing with a lot of criminal cases, particularly murder trials outside the state. A lot of cases in Haryana, particularly in Haryana state. You see, we file civil suit under Section 9 of Civil Procedure Code. Besides this, under Order 7 is a plain content, and we'll have to file a civil suit unless it is barred by any specific act. And you will have to project that there is an infringement of my legal or legitimate rights. But if you seek a declaration and an injunction, under what law you seek declaration and permanent injunction? If anybody among you will reply me, I will fulfill my commitment, which I promised.
Specific Relief Act, sir.
Yeah,
Yes.
correct. Who has said it first?
Raise their hands in an orderly manner. I know there are
No, how many?
Sir, I think right now 2 hands are raised. First is
Abrar,
Kamran, sir. And Abrar.
these two.
Yes.
They will give the account details to Danish. Right. You see, many senior lawyers I have seen in Bombay also, in Jaipur also, Jaipur High Court, the courts would ask them questions that you are filing civil suits, you filed a civil suit and prayed for mandatory injunction and declaration. Under what provision of law, Civil Procedure Code you have? Is that under Civil Procedure Code? So even the senior most lawyers did not know it. that it is to be filed under Specific Relief Act.
Relief Act.
So that is number one. Very good. Nice. Abrar is studied. And who?
And sir, Kamran.
Kamran will I will instruct Danish, he will coordinate with them.
Sir, it is section 35 of Specific Relief Act, to be
Very
more
nice.
specific.
Good. The two people only. But how many are online with me today?
There's more than 50 people, sir, right now.
Only 2 people said it.
5 or 6 of them have raised their hands, to be fair.
So I leave it to you. You can give me the detail of 6 also, no problem. It hardly matters. But I leave it to your discretion. So anyway, if any sort of query you would like to have, or question or clarification in respect of any of, because you would find me in this Union Territory state. Today I was scheduled to go to Delhi, but since these are now Diwali holidays, otherwise tight schedule everywhere. But my pleasure also to interact with young people.
Yes, sir.
First maiden experience. There were a lot of, must be having a lot of expectations, all these youngsters. Good. Mufti Javed has also joined, a good friend of mine.
It is our pleasure to be here, sir. And not only juniors or youngsters, I believe there are many senior people in the audience also who are watching this lecture. And right now,
I don't know how many people you must be having my introduction fully.
I want to say greetings and hi, assalamu alaikum to my senior sir. This is Abdul Bari from Anantnag.
Bari, very nice, very good.
Yes, sir, fine, sir. It's a pleasure, sir. Wonderful, sir. Yes.
Assalamu alaikum, sir. I'm Asya Beg from Delhi, but basically from Kashmir. You know.
Asya Beg is in touch with me in Delhi.
Yes, sir, my pleasure, sir.
She's from Kashmir, and on my recommendations, she's doing good work in one of the companies.
Yes, thank you so much, sir.
Yeah, it was only
My
on the
pleasure.
basis of recommendations. She's settled in Delhi now. Good.
Yes, of course, sir.
I think there was some my hand in that.
Yes, of course, sir. Of course. And it's nice having different kind of different courts here and going there. It's I'm liking the procedures here also. I have practiced it in Kashmir also, but then I had a gap. Then I came back to this profession because this profession is one of the best professions. I have switched from a corporate job to the practice once again.
Good, Asya, good.
Thank you, sir.
Very nice.
It's because of you, sir.
Good.
So, if it's about time, as you requested, sir, we would also have an interactive session now. And then, since we have a lot of time till the lecture ends,
Yes.
A lot of people will actually get to today ask their questions because usually we run short of time. So, anybody who wants to ask sir any question, you can either raise your hand, we can take your question live through video or audio, or you can write in the chat also if you have follow-up questions with regard to these questions. So, we are beginning the interactive session, and let's benefit from the experience of sir. And Kaisar Mahmood has his hand raised, and Abrar Ahmed. I'll start with Kaisar. Mr. Kaisar Mahmood, Assalamu alaikum.
Assalamu alaikum. Sir, basically, I'm a fresh advocate practicing at District Court Banipura, sir. And I feel pleased to attend these classes. And sir, my question is simple. Like, sir, I have joined the bar since for 1 year, sir, and I intend to practice in high court, sir. Sir, my question is, should I join my district court or should I join this high court? As I'm unable to answer this question to myself, sir. I am first generation advocate, sir.
You should always practice in the lower court, where you can learn a lot of things. In high court, what you learn, you see, there is only the writ. Most probably, the writ proceedings are only like a petition or an application. But basic procedure, you have to learn it from the lower courts only. And at least I also spent near about 6-7 years in lower courts before going to the high court. And now, by grace of Allah, I can't praise myself. I'm not in a position to praise it like that. But I have been appearing throughout the country, besides the Supreme Court also. I did a lot of very important matters in the Supreme Court also. And but as far as the other high courts, honestly speaking, I learned only from the basic procedure from the lower court only. 7 years I spent in lower court. I think you should not jump immediately to the high court. Better is to get, and then automatically you can generate the litigation also from the lower courts. So best is to learn the procedure, civil procedure, criminal procedure, evidence act, special relief act. And that practice you can find it only in the lower court, not in the high court. So I think my advice is like that.
Next, we have Mr. Kessler is done. Next, we have Abrar. Assalamu alaikum. Are you here? Mr. Abrar, kindly unmute yourself and ask your question.
Assalamu alaikum, sir.
Walaikum.
Sir, is there any exception when this Garnishee order cannot be issued? Like we have provision in the CPC that there are some this mentioned things which cannot be attached by a civil court while executing the decree.
No,
Like
as I told you, this is not a mandatory, it's a discretionary of the court. But it should be endeavor of the honorable judges to see, because decree is required to be satisfied. So if there's a money available in the bank or in any financial institution or any other movable property, why the decree can be satisfied. So this Garnishee concept came only after 1976 amendment. Earlier it was not there, because the courts, it has found very lot of difficulties during the execution proceedings. As you know, in execution proceedings, there are some decrees which are not executable also. Like a decree against infirmity, like a decree against infirm person, like a decree against a dead person. So those are not executable. So this eventuality the court faced at several times before amendment was carried. So they were not in a position to execute, because there were companies or the persons who were avoiding to satisfy the decrees. Then this concept came into being, and then automatically this is a remarkable amendment which was taken, a landmark amendment which was taken. So it is not like that. However, it is not mandatory, it is a discretionary. And there is no impediment, legal impediment in this. The judges, I have seen it elsewhere in the country also. They are trying their best. At least the person who will fight the litigation for 10, 12 or 20 years will get a degree and it will remain unexecutable. It's not permissible under law.
Thank you, sir.
Thank you, Abrar. Thank you for asking that question. Sir, I myself actually have a question before the others. I think Bari Saab also has raised his hand. I would like to, sir, just briefly, you mentioned the insolvency and bankruptcy code as well during the part of your substantive lecture.
Yes, sir.
Sir, in 2019, I had the good fortune of being an intern, interning at Shardul Amarchand. And I was dedicatedly attached with the IBC team. So there I learned the basics of IBC, the secured creditors, how this insolvency process, the CIRP that goes, the entire norm changes that have been made. And sir, thanks to your good self, I mean, I have also recently read this Doctrine of Garnishee. This particular word I did not know. So sir, when, let's say for instance, there is a secured creditor under the IBC, if there is a new regime after 2016, a secured creditor has to realize what is owed to them in the CIRP process. So, under the scheme of the IBC, would a Garnishee order be considered something that can be overriding over the CIRP process? Or
No, it is only in respect of commercial. It has nothing to do with that. No, absolutely not. Yes.
not at all?
Not at all. Not at all. No. It's only for, you see, the civil money decrees would normally, you see, Bombay High Court has retained original civil jurisdiction. I'm just, because I did face this Garnishee problem in one of the matters, which is still going on in Bombay High Court. It's one of the leading company in Delhi. I have been appearing in that as a senior designate counsel for them. And I'm settling Bombay in respect of many other companies also. I have one national reputable company, must have heard that name, Ganesh Benzoplast. Is Ramesh Palani is the managing director of that. He's one of the best company. You can check it. It is sister concern to, may not be a sister concern, but somehow it is related to He is also related to so that is one of the highly, sophisticated, I can say, very reputable national and multinational company, Ganesh Benzoplas. I'm just standing counsel in the Supreme Court also. I've done a lot of matters in Bombay also. This Garnishee concept also I did face in Bombay. That is why I'm telling you frankly. When I filed the execution petition, initially I also filed. I thought that for abandon caution, because there was no decree sheet prepared by the registry. It was their mistake. Unless there's a decree sheet, you cannot go. Now there is also now amendment made. Now the last portion of the judgment would be read as decree sheet. That is also the judgment which has been recently also delivered. But unless you have the decree sheet, you have the judgment, decree sheet is prepared, because you all of you know that decree sheet would consign the relief which is granted. To that extent, it would specify in the decree sheet. But you will not be in a position to go for execution. And then that company, Italian company, we have traced out that I think the Bank of America, State Bank of India, and there is another third bank also. They have got a lot of money. We are getting that attached, and hopefully we will satisfy. And that is 6th December. I am scheduled to appear in that matter also. This is, I think, the judge is convinced to that extent. So therefore, it has nothing to do with insolvency. A special court.
It is just a realization of the degree. Admiralty. Yeah. So Pirzada Bari Saab also has raised his hand, and Mr. Kamran Loan once again. Bari Saab, you can go ahead.
Bari Saab is a very enthusiastic lad. I know Bari Saab very well. He's a very good lawyer.
Yes, sir. It's my pleasure, sir. I once again offer salam alaikum to you, sir. My pleasure. I have been otherwise also regularly attending this court cast lectures. I say repeat, that's one of the enterprising and innovative ideas, and first of its kind in our valley. And otherwise, we have a bitter experience of using the WhatsApp groups of the lawyers, and now I salute all the members who have pioneered this mission, so that is going to set up a good example and a culture of academics as well. And I feel wordless while I don't know how to stand before my senior mentor who has been there. I spent a small time in the Honorable High Court, and the sir has been there, my senior. It's after a long time we're undergoing a lot of tough times because of the then post-COVID situation and other things. Now, I hope now these things inter alia are going to change the scenario a little bit. Sir, we have situations. So for example, once a court passes we illustrative case, for example, is that when a court passes a decree, is a decree based on contract, Your Honor, sir?
Yes.
Sir, what the contractor has done, he is not availed this e-tendering. He has undergone the e-tendering process. Now, actually, there used to be the tendering, manual tendering, the physical tendering. Now, after that, it has just switched. I've been switched to the e-tendering, electronic tendering process. Now, what happened before this abrogation of Article 370? I suppose there is one set of rules, the standard set of rules called as GFR 2017. That's General Financial Rules 2017. It's a standard document. It contains a set of rules about the financial implications of fiscal policy with regard to how to manage the contracts, how the government should procure contracts, award contracts, and the procurement of the work also. There's another manual from Finance Department that called as procurement manual. is an identical document with that General Financial Rules 2017. I have been facing this situation. That's why I got a chance to ask this humble question, that even though I may not be able to pose the question itself, but what I want to humbly request is that has it got retrospective effect? Means a person contractor who not availed e-tendering and then he has bagged a degree, for example, somehow he has bagged a degree from the court, and now as a matter of defense by the judgment debtor says that when at the time of procurement of the contract he has not gone the e-tendering, and it is hit by the GFR. The GFR provides for that the contractor should have gone for the e-tendering, lest he is not entitled to the this payment. But at that time, GFR was not operative. Sir, if I am not exaggerating, sir, my humble request is that GFR is not intended to take away the rights by which of the decree of the court. No, this is a confusion. That a person is with a decree, but he is not able to reap the fruits of the decree only because the GFR comes in his way, which provides for the e-tendering, sir. Sir, what is this? How to balance this conflicting situation, sir? Hope I am able to put the question, sir.
You see, basically, if any act is being promulgated, or if it has come into, it has been given effect, under Janaka, everybody knows, you must be knowing it. Every amendment or promulgation of any act is having a prospective effect.
Yes.
There is no retrospective effect in any of the proceedings, unless it is specifically mentioned. That's very important. So, I think that is the best I can give to you. Unless there is some legal impediment anywhere, it can't be applied retrospectively. So, and even for execution also, these pleas cannot be taken. So you will have to project like that.
Right,
Yes.
sir.
Unless it is mentioned or contrary is proved. But it is always,
Yes.
That is a Galla clause, that every act is having a prospective effect.
Prospective.
It hardly matters for reorganization act or after. Can't be, it has not been Article 370, we don't have the full concept about that. It is not abrogated. It is diluted, not abrogated in that way.
Right.
Absolutely.
Right.
We have a wrong concept about that. It was not perfectly without prejudice to my friends. For some reasons, despite of the fact that there were a lot of requests made to me to personally file an application, a lot of lawyers from Srinagar Hospital,
Yes, sir.
very senior most lawyers. But it is not in that way abrogated. There's a complete topic I have written in 2017. It is available also on my page about that. Anyway, this is subject before the Honorable Supreme Court regarding that. But the term word is not abrogation. It's not abrogated. Absolutely not. Must not be having that concept. The lawyers are saying it is abrogated. Absolutely not. And the manner in which the matter is subject before that, we are expecting the judgment, I think, before the retirement of Justice Code. Hopefully after Diwali, a little bit, I can guess it from the atmosphere in the Supreme Court. Most probably after 20, they will deliver the judgment. Hopefully. It's I'm not having it firmly, but I could. Yes.
That's a revelation for us. It's a news for us.
Thank you, sir. Thank you for.
Sir, one last question. It's a small, brief question, sir. Can I know that is there any literal meaning of the word garnishee, sir?
It is derived from the French word garnir.
Got it.
And
Garnishee.
yeah, garnisher is the judgment, creditor and decree holder, and garnish is the person where the money lies, like a bank or a financial institution. He's a garnish. Okay. This is a concept. Right. And is a Bari speaking?
Yes, sir. Yes, sir.
Yes, sir.
Mr. Bari, I hope must be having your practice, I think, more than 12, 13, 15. How much practice you have?
15, yes, sir, 15, sir. 15 plus.
I know it, 15 years.
Yes, sir. So this was because of your prayers, sir. Thank you.
concept is very, very good. And it should be in the subject. It's a very remarkable amendment. A lot of decrees are satisfied because of this. Earlier it was not.
Yes, sir.
So all these situations we were facing.
This question is connected with the Garnishee and the GFR rules, sir. Because what
Yes.
the honorable courts have been doing, they direct the treasury officers to
Yes,
deduct
absolutely. They
money
will directly
from
to
the
them.
government exchequer, sir. That's why it
Absolutely.
is connected with that, sir.
It is connected, correlated. You are absolutely right.
That's why, sir. I posed this question.
No,
Anyway,
that's
sir,
correct.
thank you very much, sir. It's nice after a long time, sir. God bless you, sir. Thank you.
Barry, you practice in, I could not see you in the High Court for last time.
I am predominantly in Anantnag only, sir, because I am working as standing counsel for that. I am being for that.
Very nice, very nice. Good. And I am reading on your your pages.
Yes, I have been constantly following you.
Yeah, that's good. Very good. Very good.
It's my honor always being associated with you always, sir.
So
Since
nice.
I've been
God
sure.
bless you always. Allah bless you always.
Thank you, sir. Thank you very much.
Yes, sir. I think very succinctly you have explained the whole concept behind the link between this Garnishee order and Section 6 of General Clauses Act, I believe.
Yes, absolutely.
So we have another question now by Mr. Ishfaq Abdullah. Sir, if you're here, kindly unmute yourself.
Thank you, sir. Assalamu alaikum, sir.
Ishfaq. I don't know whether he knows me very well or not, because most of the time I'm only out now in this part of the Union Territory. It is only occasionally you must be seeing me in the court, perhaps. Ishfaq. Is he practicing in Srinagar or Ishfaq is practicing somewhere else?
Ishfaq sir, are you there? Hello? He was just here, sir. I think he has lost his connection.
Mm-hmm.
I think he was just, or he has muted. Let me check, so just give me a minute.
No, but one who would be interacting, I must be, please tell him how much practice, that I should also know. Whether he has 5 years, 7 years, so that I will be also enlightened, because of, let me see where our generation has been, the young ones.
Yes, sir. So I believe Mr. Ishfaq Abdullah has lost his connection. I think there are some connection issues with the meeting that he's having. So he's not there in the audience right now. If anyone else watching wants to ask any questions or pose any sort of queries or have an interaction, kindly just raise your hands and go ahead. There was one hand raised, Lord, I think. So even now, people are trying to access the link and join even now. So I have just kept it open for everyone's convenience.
Absolutely, no problem. We have time today.
Yes, sir. So regarding, regarding General Clauses Act, you mentioned about Section 6.
Yes.
The effect of these legislations. With regard to IBC, I had also asked this question. You said that it is merely for the realization of the decree that we have. So as far as I had not heard the term Garnishee before. So I read about this a little bit in the past few days in the history of the amendment that you talked about.
That's why I selected this only, because I thought it is better to apprise everybody.
It is a very new word for most people here, I believe.
Yes, you must not be having, even in Jammu also, I told many senior lawyers, and they said we have heard it for the first time. We were not knowing it. Yes, honestly. Otherwise, we could have selected any topic in civil procedure court. I can't claim that I have any master in civil procedure, but little bit I also know, tip of the tongue. But this concept was very important, so that everybody is apprised about this, and they will come to know how this was incorporated in the civil procedure code when it came into being. So that is very important, because they will face this type of in the decrees when they will get the decrees and go for execution of the decrees.
Yes. So for the information of everyone here, for example, we see this under Order 21, Rule 46 of CPC, the orders of garnishment. But as far as I could logically infer, let's say there is a decree, there is a judgment debtor, there is a decree holder. Now the judgment debtor might try to escape or avoid his liability in a sense that I am unable to fulfill the terms of the decree. That is where I believe the Garnishee doctrine can come in, right, sir?
Absolutely, you are right. If he will avoid, as far as he will not provide his assistance and will not go for satisfying the decree. You see, under Order 21, there is also procedure you can go for punishment. That is a routine way. routine way of punishment, but how to get that money is a decretal amount. So this concept is like that. If one would try to avoid, somehow there are many tricks one would play the judgment debtors to court. But that's why this is very important concept. It's a good doctrine in the civil procedure code, and hardly anybody can escape from his liability as far as certifying the decretal amount is concerned. Yes.
So
that's very important.
In the meantime, I think there are some people who have asked that's the message during which you would ask the earlier question, sir.
And even then we would go to law college. I have also done my law from University of Kashmir.
Yes,
I think that time this was not there. It was, though amendment was there, but I could not find it in syllabus that time. It was not in the syllabus. This Garnishee. No, these civil procedure, summoning of witnesses, plaint, written statement, then issues, documentation, admission denial. I think those were mainly in the civil procedure code when I was also in law.
Yes, sir.
But very important doctrine is Garnishee. Yes.
So Mr. Abrar Ahmed again has a question. Anyway, this is his first question. He had raised his hand earlier during when you had asked about specific relief act. Abrar sir.
Abrar, yes. Abrar, please introduce yourself. For how long you are in the practice, and
Sir,
where are you practicing? In Srinagar or in any village?
I'm Abrar Ahmed from Nishat basically, and I'm practicing in Srinagar from last 7-8 years.
Good.
With Advocate Ishtiyaq Ahmed Khan.
Okay, where from you have done your law?
Sir, I have done from Kashmir Law College.
It's a private law college.
Yes, sir.
Good. Affiliated to University of it must be that.
Yes, yes. Yes,
good. For last 7 years.
Yes, sir.
So you are doing civil matters or criminal matters?
Sir, both civil and criminal.
You are not independent as yet. You are still as associate of Ishtiyaq Khan.
Yes, sir.
Good. A good friend of mine, Ishtiyaq.
Yes, sir. Sir, I have one more question with regard to same topic, Garnishee. Yes. Sir, suppose I being a judgment debtor, I have given a check to a third person for presentation before the bank, and meanwhile, a Garnishee order is issued by the executing court. Whether bank will honor the check issued by me, or it is bound by the Garnishee order issued by the court?
It is bound by the way. That amount is due. It is bound. Absolutely. He has to implement the court Garnishee order. You have to mention only about that amount in the check.
So what will be the remedy available to the person whose check then is bounced, which is not on?
Oh, that is separate. That is a separate issue. You will have to go for 138. That has nothing to do with the Garnishee. If it is bounced.
Sir, there another question lies, sir, because something which is beyond the control of the accused. The Garnishee order has been issued by the court, and check
Garnishee order will be, if it is accounted there, the check is amount is due. You will have to apprise the court. You have to be also smart. The decree holder has to be also smart. He has to watch where the money is there. If there is a check issued, if it is credited into his account, immediately you go and obtain a Garnishee order. The bank has to honor. And if it is bounced, the separate proceedings 138 we can launch. That has nothing to do with the Garnishee order. If it is bounced.
Okay. Thank you, sir.
Sir, before another person, Mr. Ishtiyaq Ahmed Mir, sir has a question. I would just like to ask you, sir, what is the interplay between, for example, the doctrine of Garnishee and contempt of courts? What would be a better way for realization of that particular
it will be contempt of court. I have also tried to convince many judges about that. You see, subordinate courts, they don't have the powers to punish civil for a civil disobedience. We'll have to make a reference for that if they will find. Believe me, as a gentleman, this topic I touched with one of the chief justices of our Honorable High Court, even in other high courts also, about that, the powers of contempt or civil disobedience, which ordinarily would find under that Order 39. Rule 3, or yes, something like that, yeah. So, but punishing power with the subordinate courts is very limited. What is the procedure to be followed, unless they will refer it to the High Court for confirmation and like that. And I think that this is the time, need of the hour to go for some amendment to that extent also. Because the powers, the lower courts, the subordinate courts, the district courts should be, or the civil courts should be connected with all the powers. They should be given these powers to punish directly for day in and day out. We are seeing. You see, I, honestly speaking, in 37 years or 38 years practice at bar, hardly, and this also in one of the proceedings just recently, before one of the honorable judges, I told his lordship that I have not seen any honorable judge of this high court punishing anybody, any person who has with impunity committed flagrant violation of the court order. I could not find it. And that judge, I told him that it's very easy that you will punish a lawyer. You will send a lawyer to the jail. You will immediately order for a lawyer to be taken into the judicial custody. But I could not see any judge, honorable judge, passing an order and punishing any bureaucrat or any type of authority in the state and state of Jammu and Kashmir. Because the judges should, even the high court judges, you see how many contempt petitions are pending in the high court. Have you seen the persons who are practicing maybe 7 years later? Have you heard any time that anybody has been sent to jail or punished in a contempt court? Never. Otherwise, you see, contempt, high court is the court of record. Under Article 215 of the Constitution of India, high court has the unbridled, unfettered powers to punish a person for a violation of the court or for committing a gross violation of the court order. And besides the Contempt of Courts Act of 1971, that is also there, applicability. But since the Constitutional Court, you leave about the subordinate courts, how you can blame a principal? I have seen it. You see, as far as contempt concept is concerned before the district court, if a municipal court will pass an order, will restrain anybody from raising any construction, he would raise it and then file a contempt. Hardly there is statutory or any sort of disobedience orders. The subordinate courts will get. They are afraid of that. They would never punish anybody or will pass an order for punishing anybody, despite knowing that there was a status quo order or a restraint order, but still that person has gone for the construction. And day in and day out, you would have seen a lot of lawyers filing contempt petitions into subordinate court. This is the height of thing. And even the high court judges, honorable high court, with all respect, immense respect to their lordships, never find. That's why just quite recently, I submitted before Honorable Justice Chatterjee Paul that this is that you should rise above the occasion and punish these officers who are brazenly committing the violation of the court orders. And we live in a democratic country where rule of law prevails. Majesty of law is to be maintained. Supremacy of law, you have to uphold the supremacy of law. That is therefore contempt concept very difficult here in the state. But honestly speaking, in just quite recently, there was a contempt petition in the Bombay High Court, and I was gossiping with all the senior designated lawyers in Bombay High Court. There is a third floor, separate room for, it's a big room, but seating arrangement for designated senior lawyers is separate, and we would interact with each other. Then one of the senior designated lawyers was telling other lawyer that what happened to that contempt. So there is no like that. The violation is not palpable in Bombay High Court, and elsewhere also I see. Only here in state of Jammu and Kashmir, I don't know. Either the judges should show them the teeth, law should show them the teeth. We have the teeth. Show them and bite them if they commit the contempt of court orders. But hardly, seldom to do it. But in Bombay High Court, they were very surprised that contempt petition has been filed and the person has been caught and he will be punished now. He has the cheeks to violate the court order or to defy the court order. So, but that concept is not here, unfortunately.
Yes, sir. Thank you for that answer. I mean, that clears up a lot. There is also preferential thing in Garnishee versus. So now Ishtiaq Ahmed Mir and Miss Asia Beg again have questions. We would start with Mr. Ishtiaq Ahmed Mir. Assalamu alaikum. Kindly unmute yourself.
Assalamu alaikum, sir.
Walaikum Ishtiaq.
Sir.
First, who is the host? Please, host Imran? Kamran?
So I am the host.
Iftikhar,
your good name, Iftikhar. Iftikhar, who did raise hands now, you please tell me the name of those.
So Mr. Ishtiaq Ahmed Mir and Miss Asia Beg.
No. When I asked it, show the declaration, decree, the relief or declaration and injection, somebody said another special relief.
Abrar and Kamran.
Give me. 1 minute. Give me 1 minute.
Surely, sir, surely.
Ahmed and Mr. Kamran, I think he's still here. Mr. Kamran.
Abrar?
And Kamran, sir. Kamran.
Please tell Abrar how many practice when he joined the bar.
Mr. Abrar, you kindly unmute yourself and how many years of practice? He said 7, I think 8 years, sir.
8 years.
No, 8 years old, Mr. Ishaq Khan, if I'm not wrong.
Abrar and Kamran.
And Kamran.
Kamran, how much practice he has?
Kamran, sir, is not here anymore. I don't think he's in the meeting right now.
Okay, please.
Yes,
Kamran, anyway. Okay. Who is the next?
Sir.
Yes, sir.
Ishtiyaq, sir. Ishtiyaq Mir, sir.
Ishtiyaq Mir. Please introduce yourself. When you have joined the bar, from which college you did your law degree, you are practicing mostly on civil side or on criminal or on a constitutional side.
So, firstly, fortunately, sir, I am the batchmate of Mr. Iftikhar, who is hosting this meeting, sir.
Good.
Sir, I have the experience of almost 3 years. I am a passed out of 2020, 21, I guess. So, it's 3 years experience, but in those 3 years, I did my LLM for 1 year, sir.
From which university?
Sir, from National University, Shimla.
Okay, good.
And sir, I have done my law from Kashmir University.
Good. Very nice.
Sir, actually, sir, it's always pleasure to learn from such seniors like yourself, sir. And we're fortunate enough to be bestowed with such seniors, sir, because in present times, we don't get much of that, but still we're so fortunate, sir. We have seniors like you, sir. We've been following you since that hijab row controversy, sir. We have followed you, how you present the case, sir. It was, sir, awesome, sir. Actually, one of the points that you made in that, sir, you said that there was no need to bring that essential religious doctrine. And that was exactly what the Justice Sudhanshu Dhulia in the split verdict. The Justice Supreme Court, sir. Sir, he said the same thing, that there was no need. Why have you brought this doctrine?
Absolutely.
It's ultimately the girls who are getting the education. What kind of anxiety do you have? Why are you getting this essential religious doctrine into this? So, sir, that was quite impressive, sir.
Justice Dhulia, when I argued in the Supreme Court, I think
yes, sir.
I was number 3rd or number 2nd lawyer when I argued. It was given a time. Justice Dhulia openly said in the court that we were about to commit a mistake had there been not Mr. Dar. He assisted properly in such a manner, apprises about everything in that hijab matter case. And he has written in the judgment also. That is why it was, I can't say that it was because of me, but I tried my level best to convince even Justice Gupta, one who was totally hostile in that bench. But Dhulia was convinced. And he openly said to many lawyers, even Kapil Sibal was there, and my friend Abhishek Singhvi, I told them that Mr. Dar apprises properly about this concept. And we could say that secret of that because of that split. Yes.
So that was quite impressive, sir.
Very good. Good.
Sir. So actually, then he made this remark. Actually, the observation, he said that it's actually the Article 21 which has to be given precedence over 14. So
Absolutely.
14 was their contention of the state. They said there should be that uniformity. So I'm not to go into that, sir. Actually, sir, I don't have the question, but may I kindly seek your suggestion, sir? Sir, actually, I'm getting a matter wherein, sir, my land is in the possession of CRPF.
Okay.
So they're in possession of that since 90, I guess. So I have bought that land. I have purchased actually that land in 2005. Now I want, sir, that land for my personal use. I have, sir, contacted them many a times. Even I went there and I asked them to kindly leave this place, and because I need it for my personal use. So, sir, they're not doing anything. So, sir, what should I do? Should I go for the eviction suit or what? So what would be the proper and effective remedy?
I have done it in many matters, even related to one of my relatives also. The KRP people had even that also at Hotel Taj Vivanta. See, you know that I am their regular counsel. In that also, it is not possession. It is under their occupation. There's a lot of difference between possession and occupation. is under occupation. Maybe it is under their occupation. You can say it legally or illegal. That's something different. They can't have the possession of any property, of a proprietary land or a property which belongs to somebody, and you have also purchased it. Then you have a remedy to go straight with writ petition under Article 226, and no need to go for eviction. Who are they? They are, for all practical purposes, only occupiers. They don't, claim to be having the possession, whether adverse or something like that, or having control. Who are they? You simply go. I have filed even for Shiraz Hotel also. I have filed a petition here to the Srinagar High Court. Nido's Hotel I have. Recently I have filed a Nido's Hotel. Throw them out, give us rent, and rent is to be determined by the state. It was done to be done by the state DG, and there is a committee, full committee. You can also get the rent, and also you will have to get this writ of mandamus against them. Ask them to vacate it, as this is my proprietary land, or the property which belongs. I purchase it again. So there is no need for going a suit for eviction. No, absolutely not.
Sorry to interrupt, sir, but should it be feasible at this time, given the reason of this national security?
Absolutely not. It has nothing to do. Even during militancy time, I have got vacated a lot of here in Shiraz, Safco also, Nido's also. They are all my clients. Even the land which was just at National Highway Authority, there was a full-fledged CRPF camp that was belonging to one of my relatives. And I got it. Justice Mansoor passed a judgment in that. Honorable Justice Mansoor, in all respect. His Lordship passed an order and evicted them, asked them to leave it. What right do you have? They don't have any right to that. They are all for our purposes only temporary occupiers. Can't be having the possession. Possession and occupation is a lot of difference. You must all know it.
Two different things, sir. Sure.
Yes.
Thank you. Thank you so much, sir, for enlightening us. And this was quite a good. Thank you. Thank you so much, sir. Thank you so much.
So nice of you. God bless you.
Thank you very much for that answer, sir. Now the last question is by, I believe we're nearing the closing time of the lecture also. So Miss Asia Beg has raised her hand since a while now. Miss Asia, you can go ahead. Please unmute.
Once again, it's pleasure having you all. Great work.
Your voice is not audible.
Your connection is still shaky, ma'am.
Is it audible now?
Better.
Actually, my question is, if a garnishee order is passed against a person and he died during that, will his property, will his account or whatever is to be attached, can it be attached or not? If he died,
it can be still attached. There are legal hairs also. It can be still attached. The only factor should be there should be money in that account, and it should belong to him directly first. And if he dies during the period, absolutely no problem. That it should be reflected that it was in his account before his death. It can be recovered.
Okay.
Yes.
And can salary account be also attached, sir?
Salary account whom? For whom?
So salary account be attached.
Yeah, why not? If the money is there, the degree will be satisfied. Why not? That's all about that. It's very easy to get it.
So in the case of maintenance, that will be good.
Absolutely.
Why not? Why not?
Thank you.
This is a good weapon with the court now after amendment in 1976. Garnishee. Garnisher and garnishee. Very nice.
If I might add, a very hidden weapon which we were not very well aware of until your lecture till us. Mr. Abrar Ahmed has another question. I think, sir, you've given us a lot of your valuable time. So,
yeah, no problem. You are all my, belong to the family. All youngsters like my son. Absolutely no problem.
So
I've heard Danish is my son. He's doing the practice now.
Yes, I know him very well.
All of you are knowing him, but I don't know whether everybody knows him or not. But must be knowing him, Danish.
We keep meeting in the court, so it's always nice to meet.
Asia must be having implied introduction about Danish. Must not have seen Asia.
Yes, sir. I'm not little bit of voice. I'm not able to get you, sir.
You have you heard about Danish practicing my son?
Yes, I have heard about him, but I have not met him, sir.
Not, yeah, correct.
Yeah.
So Mr. Abrar Ahmed has the last question. I believe after that we'll
Abrar is the same?
Yes, sir, same one.
Abrar, yeah, please. Abrar, you will,
Sir,
you know the
same
number of
question, sir.
Danish? Danish?
Yes, yes, sir. Yes, sir. I know him, sir.
You have his number? Cell
Yes,
number?
sir. I have. Yes, sir. I have.
We'll just contact after some time, no? With him.
Sir, I have same question as was asked by my sister, that salary account can be garnish order can be, whether pension account, with relation to pension account, whether garnish order can be issued.
You see, if there is a decree against that person and even he has, you see, salary and pension under service jurisprudence also considered to be the personal property. It falls within that. It's always a personal property of an employee. And if that is a debt due, decretal amount is to be satisfied, why not? There's no problem for that also.
So basically, it is a suppose there can be an objection that this is a survival amount. A pensioner.
Survival will not come in that way. Survival will not come in that way. You see, if decree is existing against him and if it is in operation still and he owes money, there's a decretal amount, a money decree. Suppose a person is drawing, leave the pension first, let us see the salary. And if salary is 2 lakh or 1 lakh rupees, if a decretal amount is 1 lakh, it can be recovered. What's the problem for that? After all, you have to satisfy the decree, no? And he must be litigating in the court also. Regardless of the fact he's an employee, it is his salary amount or but the court has a discretion. That's why it's a discretion with the court. Court can say we can satisfy this decree. And this amount you owe to this decree holder. You have to give it to him. You see, this is related to the commercial transactions, money decrees, basically. And for that satisfaction, why? You will not enjoy. You will enjoy with your salary and will not satisfy the court decree. I think besides satisfying the decree, he should be also punished, reprimanded. Immediately recover that from his salary.
Yes, sir. So I believe that was all the questions. We are very thankful for the time you spent educating us and elucidating on this topic of Garnishee or a lot of other things which you have also mentioned, which would have brought things to light.
Next time also, whenever you would feel subject to my
schedule,
that you will have to find out, and anytime, constitutional or insolvency, commercial, or like these admiralty suits, these type of anytime, whenever you like.
Provided, make sure that the next time, inshallah, that you are on here, it will be a commercial litigation or commercial arbitration topic.
Anytime, even for constitutional matters, absolutely. Yes. No. Because in Supreme Court, I am dealing mostly the constitutional matters. No? It's very sensitive constitutional matters. And for company matters, there are 9-10 companies presently with me.
Yes.
And mostly I am busy with those, and that's why I am shuttling to Mumbai, Rajasthan, Punjab and Haryana High Court, Allahabad, and Delhi. Delhi I am regularly. So anytime any friend can come to my chamber also in Delhi. If somebody would happen to be in Delhi anytime, and Asha is there. She met me last time there. Then I introduced her to one of my good friends. Has got a very good litigation in Delhi. She's working there only, and I hope she will rise. She's a very talented lady.
Thank you, sir. And I need all of the lawyer brothers and sisters' wishes.
She is doing a commendable work. I think I can request everybody. Always, I will be. Can't say. I'm a very down-to-earth person. I have risen from very humble background of my family. Always at the beck and call of my junior lawyers.
We are incredibly grateful.
They are anytime, whenever you feel any sort of difficulty, you will find in Delhi, Mumbai, anywhere in Chandigarh, or anytime, even in Srinagar, you do come to me. Just call me anytime, any convenient to all of you. Don't be so reluctant having any inhibition. I'm not that type of person. It's down to earth, always, I think.
We are very grateful, sir, for having you here.
I wish every youngster to rise and shine. Must be all the what I could feel today. I could sense it with all humility. Very good, talented people, and having a very good interest in this profession. I've seen people doing practice for some years and then leaving the profession. It should not be like that. You should take this profession by your conviction. And you see, I belong to this area in Srinagar, Batmalu area. There was hardly any way. I'm the first generation one. But it is, I can't say that I'm praising for myself. I need not praise. The praise should come. It's always from Allah. But without there being anyone Godfather, or no any support, but support from Allah only. Now I am handling near about 10, 11 those companies by a person would not even think in a dream. And this Bombay firms, Bombay companies are engaging me even from Srinagar. So I think that is very important thing, and it is because of you will put your all, work hard, concentrate on your subjects, and this is such a noble profession. Need not to worry about the fee. It is not that I am senior designated and then I can ask the company to give me this one. Before even senior designated, I was doing company matters in Delhi, Mumbai. Before that, and whatever I will tell them that this much should be my fees, and then for conference, you will not believe. For Benzoplast, I did some conference with them, and they had already acknowledged the talent from Kashmir. I think that is very good. So I wish everybody to work very hard. Should also reach to every high court. Talent is there in Kashmir. There is nothing. There is no dearth. And you should just try to get, if you will somehow get the briefs also from outside. Try to work there, learn and concentrate on your subjects. I think my all best wishes to all of you. And anytime we will have a get together also. That I leave it to the host. Anytime we get interaction, either for lunch or dinner, anytime.
Inshallah.
I will be the host that time, but you select the venue and the time.
Inshallah. It has been enriching. Thank you so much, sir.
Sir, before you leave, I have a very humble submission to make for you, sir. Sir, actually, I also answered your question, so sir, so my name should also be included in the list, sir.
Yes, sir.
But your name?
And sir, I mentioned section as well, so it's my humble submission.
What's your good name?
Sir,
Yes,
my
sir.
name is Kaisar Mahmood, sir. I am from Wandipura.
Hey, 1 minute. Kaisar?
Kaisar Mahmood, sir.
You give me your number.
Sir, yes, sir.
You do one thing.
Yes, sir.
You send your cell number to the host.
Yes, sir.
He will inform Danish, and from his reward, it will be credited to your account.
Yes, sir. Thank you so much, sir. Thank you so much.
All the three. Only 3 people are there.
It was very nice.
3 people only there, or?
Yes, sir. These 3. I saw 3 of them.
Huh?
So far, I saw 2 of them and him also. I mean, I think it had slipped my mind.
They will contact you, give number to the host, and host will forward to Danish. You will find in your account. 100%. Very nice.
Thank you.
It's very nice.
Thank you, everyone.
Allah Hafiz.
Thank you, everyone.